speaking, with me, Tarun Nangia. This is a show that hundreds of promoters of companies in India that may be admitted to the IBC process or have been admitted to the insolvency and bankruptcy process will watch with extreme caution and extreme interest. Why is that so? Justice Indira Banerjee and Justice J.K. Maheshwari of the Supreme Court have passed a landmark judgment. Now, what does this judgment say? That the effect of this judgment is it is not mandatory for the NCLT to admit application in each and every case where there is an existence of debt, which means if the financial creditor files an application under Section 7, the NCLT has the jurisdiction not to admit the application, which means that this will mean hundreds of companies which may have been admitted to IBC which can now be revived. The promoters will get one more shot at revival of the company. And I have the experts with me to discuss this very important judgment authored by Justice Indira Banerjee. And let me introduce you Mr. Mahesh Agarwal. He is managing partner of Agarwal Law Associates, one of India's leading litigation law firms. I have with me Justice M.M. Kumar. He's first president of the National Company Law Tribunal, authored himself many landmark judgments, many of the first big judgments in the IBC. I have with me Mohit Saraf. He's managing partner of Saraf and Partners, now fairly with 200 lawyers, can be called one of the biggest law firms in India. Let me first request Mr. Mahesh Agarwal to lay the ground in the first 2 minutes of what happened in the court before we move on. Over to you, Mr. Agarwal.
See, the law so far, as interpreted by the court, was if there is a debt, it is established that there is a debt. If there is a default, it will lead to death. Death, default, death. That is it. Correct? That is how Section 7 was interpreted. For the first time, the Supreme Court was called upon to consider the word may used in the section. This has never come into consideration earlier. So the court has interpreted that the word used is may cannot mean shall, so therefore there's a discretion. Meaning thereby, if there's a debt and there is a default, it is not necessary for the court to admit the petition against the company. It has to apply its discretion. Discretion has to be informed by reasons. Now, there may be cases where a company is unable to pay, but the company is able to establish that at the same time it has, say, court decrees, it has arbitration awards, where it has to recover monies. So it is in a situation that it has to recover money, but there is a temporary stress because of which it goes into a default situation. So the court has said that the NCLT must apply its mind and exercise discretion and come to a conclusion as to whether this company deserves to be admitted or not. Now, this is a sea change from the situation which was happening earlier. Earlier, the situation was the financial creditor will go to the court and say there's a default and the company has to be admitted. Exactly. The court has also contrasted the difference between Section 7 and 9. 7 is for financial creditors, 9 is for operational creditors. The word used in 9 is shall. So the court has said the legislature or the parliament has consciously used the word may, given a discretion to NCLT, and discretion must be exercised in a proper, cogent way. There may be different circumstances where different discretion is exercised, but this definitely gives an opening to various promoters to establish that default is bona fide, it is not mala fide, it is for reasons beyond their control. If given some time, they will be able to pay back. So why should they be taken to insolvency?
This is a very, very landmark judgment. A lot of promoters will be able to take back their companies and run them successfully. A lot of promoters often say that they have committed payments. Payments are which going to come, but they have been delayed because of some of the others. Many times the government is a stakeholder which hasn't paid. I'll go to Mr. Mohit Saraf for his comment on this judgment.
You actually look at the entire jurisprudence on Section 7, Section 9, and I think right from innovative industry case to that Swiss Ribbon case, SR Steel case, I think the general interpretation was that Section 7 is mandatory. So if there is a default and if the money is owed, like there's an admitted debt and there is a default, then you as a right, you can start the insolvency proceedings. I think the important thing is not may and shall. Because if you look at a 2022 Supreme Court judgment, which is the Kotak Mahindra case, where there were 3 bench, and the court saw that at 55 times in that order, adjudicating authority, the word may has been used, and 32 times shall has been used. And then it went on to say that may does not necessarily mean mandatory, discretionary, and shall does not mean mandatory. And there are enough jurisprudence right from the Supreme Court level. And therefore, may and shall has to be interpreted in the context of the legislation. And that is an important part. Really, if you look at the IBC law is not a recovery proceeding. It's more of a resolution of default. And therefore, it has to be interpreted in that context. That's an important part. So really, if the way I look at it is, not multiple things have changed. I think the rule is, as a rule, it will go for admission. But the exception, the way the court has looked at it, if there are exceptional situations, the court has an ability to apply his mind. That's the only change. It does not give an arsenal to a defaulting promoter. What it gives us, it gives an, at least like if you have a degree, if there is a force majeure event, if there is some big, like in an NHI project, the land has not come, if there are certain very fundamental issue which can be shown that the promoter is not default, this is not the ordinary course, then in that situation, the courts have an ability to apply, and that's how they distinguish between may and shall. So I would say the rule still is that for as a process, if there is an admission of default, it will go to the CIRP proceeding will get admitted, but in a highly exceptional situation, the court can apply itself and disagree. That's the way I read the.
Thank you for sharing your interpretation of this judgment, Mr. Mohit Saraf. I'll go to Justice M.M. Kumar. So you served as the first president of the National Company Law Tribunal, who saw and authored judgments in many landmark cases. And I remember those days having recorded a show with you. I think Dr. Singhvi was also there, and you made one comment on that show that Tarun, it takes 20-25 years to build a business person. A businessman cannot be created in a day. A businessman is not a product of an MBA college. It is a product of a man who can take risks of thousands of crores and carry on the business. And you cannot simply create businessmen out of thin air. So that is why it's very, very important to look at each and every case closely, is what you had told me that time. Just recollecting those thoughts and requesting you for your opening comment on the show, and also commenting on the interventions given by both Mr. Mahesh Agarwal and Mr. Mohit Saraf.
Thank you, Tarun. You see, if you read innovative, para 28,
Yes.
only 4 or 5 lines from para 28, a debt may not be due if it is not payable in law or in fact. The moment the adjudicating authority is satisfied that a default has occurred, the application must be admitted. So this is the law. There were only 2 factors which would determine the fate of an application, whether to be admitted or not. One, there was an obligation to pay the debt in fact and in law by the corporate debtor. 2, the corporate debtor has failed in such obligation. Once these 2 factors are satisfied, the application is bound to be admitted. But by this judgment, in the case of Vidarbha Industries Power Limited, another factor has been introduced. I won't say that broadly the whole thing has been turned topsy-turvy. The other factor is, if the viability and overall financial health of the corporate debtor is established, these are not the extraneous matter. It is a relevant factor. For example, as was in the case of Vidarbha industry, there was an award in favor of the corporate debtor, which exceeded far more than the claim made in the petition. So Honorable Supreme Court thought that here is a company which is of sound financial health and it cannot be subjected to the rigors of corporate insolvency resolution process. But having said that, we moved from winding up procedure under section 433E, which has been deleted by the Insolvency Bankruptcy Code. There the test was inability to pay tax, inability to pay debt. But now the test is existence of a debt and non-payment. The word inability has been obliterated, has gone. So in para 68, 64, in Swiss Ribbon, the Supreme Court has explained this concept. And there are 4 reasons given for the policy shift. Now this is jurisprudentially, first is predictability and certainty. Second is paramount interest to be safeguarded is that of the corporate debtor, and admission into insolvency resolution process does not prejudice such interest, but in fact protect the interest. 3, which is most important, in a situation of a financial stress, the cause of default is not relevant. The cause of default is not relevant. Protecting the economic interest of the corporate debtor is more relevant. 4th, the trigger that would lead to liquidation can only be upon the failure of the resolution process. So this policy shift was there. Consciously, the recommendation of the committee, BLRS committee, has recommended this shift for these 4 reasons. So CIRP cannot be considered to be a onerous process as far as corporate debtor is concerned. It is for the protection of the corporate debtor. And Justice Nariman in Swiss Ribbon, para 64, has elaborately considered. When you study this judgment in Vidarbha industry, para 64 has been cited, but 64.1, 64.2, 64.3, 64.4 has not been considered. So these 4 reasons for shifting the policy from inability to pay debt and existence of debt and non-payment was a paradigm shift, which I think Supreme Court in the present judgment did not explain why they are now again deviating from the settled position. And now if we start thinking like this, for example, set off and counterclaim, this is also explained in Swiss Ribbon, para 62, 63. These 2 things have been also explained. The corporate debtor can set up the counterclaim after the admission before the resolution professional, but it will not stop the admission of the petition under section 7.
Thank you for that. Thank you for that opening comment. I'll go across to Mr. Mahesh Agarwal, Managing Partner, Agarwal Law Associates. And we are discussing the impact of this judgment on other cases going forward. A lot of promoters will watch this one. And if the overall objective of the IBC code is revival of the company and revenue maximization, so that, these companies, the employees, connect people, a healthy business environment should be there. I want to ask you, what about companies whom the NHAI has to pay? And that is why they are gone under IBC, because NHAI failed to pay. There is some, in a sense, dispute going on. Secondly, NBFCs which go bankrupt, because For example, NHAI contractors failed to pay the loans taken. Do you think this will have a windfall impact on many such cases where there is a genuine, in a sense, genuine claim made by the company against whom the IBC application under Section 7 is filed, that there is claim that they will get this money, it will take some more time. Can you explain what will happen because of this judgment in other matters?
Experience has shown that companies which are into, say, infrastructure projects, which are engineering procurement contract companies, who are doing construction work, they do not have any real asset. Now, if such a company goes into IBC, there is hardly any recovery for the lenders. In fact, the data will show that many infrastructure companies have in fact gone into liquidation, or they have been acquired at 5%, 7% of the total value, means a haircut of 90 to 95%. So although the objective was revival in the interest of the corporate debtor, but what is happening is that it is causing loss not only to the corporate debtor, its employees, and a huge haircut to the lenders. So if an infrastructure company, for example, I'm giving an instance, an infrastructure company is able to show that I don't have any asset, I have to pay a bank, say 100 crores, but I have an NHAI award for last 3 years where I have to receive 300 crores, and NHAI is gone to court objecting, delaying, etc., then what is just? So far, before this judgment, there was no option for NCLT but to accept and admit the petition. Now, there is an application of mind required. It may be an exceptional circumstance which has to be seen, but there is an option. There is an ability for NCLT to say, possibly, that I will defer it for 6 months. Let us see if there's some recovery made. Maybe some payments are due and payable. So there are ways and means to resolve an issue in the interest of corporate debtor rather than pushing it to insolvency and leading to excessive haircuts. The haircuts, have you seen in the last so many years, have been beyond imagination, and that have caused complete loss to the lenders. So the interest of everyone is revival. Now NCLT can take a holistic approach, look at the balance sheet, look at the papers, and take a view that whether I should put this company to insolvency or give it some more time to resolve the debt. Objective remains resolution. Objective remains recovery for the banks. Objective remains rehabilitation of the work and the employees and business, etc. With that objective, there is another option available to NCLT. Now, I'm sure over a period of time, some guidelines will be made, some methods will be evolved as to what should happen. If a company should not be pushed into insolvency, doesn't mean the financial creditor has no other option. There will be, I'm sure, some solutions will be found, some methods will be found. For example, I was suggesting that it could be a situation that very well I'll give it 6 more months. I'll give an option to the company to see if it can recover monies. Some resolution will happen. So I think it's a very welcome step that it is not necessary for the companies to go into insolvency.
Will it be applicable to NBFCs also?
The NBFC is slightly different chapter, but it should apply. Because NBFCs will also have a situation where, I give you an example of NBFCs, that during the COVID period, there was a bar on NBFCs to recover, say, from home buyers or people who had taken loan, they could not recover money. But they had no protection to pay the banks. So banks have taken NBFCs to court, taken recovery proceedings, or in a very strange situation that while NBFC cannot recover money from its borrowers, but it has to pay its lender. And they have been pushed to insolvency. So a situation like this has applied to NBFCs also. That's
a fair point. I'll go to Mr. Mohit Saraf. On the infrastructure side, now you spent many decades writing BOT contracts, authoring model contracts. So you understand this sector. Could you tell me the impact such a judgment would have on this sector, which is infrastructure companies, which may or may not be admitted to IBC?
My take on this judgment is a little different. It is a 2-bench judge judgment.
Yes.
And there are enough 3-bench judgment which clearly says may and shall. And again, when we are applying as a precedent, we have to look at the entire precedent, just not this. What did this court say? They say it is not mandatory. It did not say that in every situation a corporate borrower will have a right to prove. What it says is that the borrower has no right, but in an exceptional situation, if the court NCLT find some very difference, if they find a very compelling case, like a compelling case here, not a claim, but a degree. If there is a compelling case, since the entire objective is resolution, not recovery, they will pay attention to that. So really remember, most economic legislation globally are directional legislation. They are not prescriptive. Now, IBC was prescriptive because that time there was all the 3 C's were at work. And therefore, government thought that to have a very prescriptive legislation, time-bound manner, everything has to happen. And therefore, when you're looking at real life situation, like a commercial difficulty, insolvency, not ability to pay, these are real life situations. And therefore, what the court has held, that in such situation, if there is a compelling reason, it's not that they have given a right to a borrower. They've said if there is a compelling reason on record, that means, and again, remember that most financing documents are time bound. If there was no time bound, then Lehman crisis would have never happened. All the assets have been paid off. They were much more than the liquidation value. But the Lehman happened because on particular date, there was a cash flow issue. So what the court has not said, it's only said it is not mandatory. And again, there are enough jurisprudence to say may can also be mandatory and shall can also be an optional. So it's not that. What it says is, if there is a compelling situation, like let's assume in a real life situation, what happens is, Tarun, there are 20 financial creditors and one financial creditor is trying to bring the house down. Now it goes to the court because it's in a position to blackmail the other creditors. Now in a situation like that, if the court believes that there's nothing going to get done, I think we can find a way to resolve it, then they can give that time. That's all it says. It does not see, I don't believe that the court had said that we will apply ourselves and take 6 months, or we will give promoters 6 months to resolve insolvency. It did not say that. What it says is that if there is a clear thing on the paper where, and it also says that discretion cannot be used arbitrarily. It has to be reasoned order. It has to be based on facts. So if there is something like that where they feel there is a revival possible, and it's a procedural issue, it's not a substantive issue. If there's a substantive issue, like remember in this particular case, they had a degree, not a claim. They had a degree of recovery. And therefore it's an issue of procedure. If there is something like that, then you can possibly exercise your discretion and not throw the company in insolvency. And remember one thing, Tarun, this is a very, very interesting way Justice Indira Banerjee has looked at it. There can be a serious implication to financial community, to the other community, and to the promoters. And therefore, this needs to be understood very well and in light with all jurisprudence. This is not a constitutional bench. This is just a two-member bench.
I want to also understand, there are now many new judges in the NCLT, I think 27 in number. They also will look at this judgment and they will start giving their orders accordingly. And that is why I'll read out point number 88, which is on page number 33 of this judgment to Justice M.M. Kumar. The NCLT has to consider the grounds made out by the corporate debtor against admission on its own merits. For example, when admission is opposed on the ground of existence of award or a decree in favor of the corporate debtor, and the award decretal amount exceeds the amount of debt, the adjudicating authority would have to exercise its discretion under section 7 of the IBC to keep the admission of the application of the financial creditor in abeyance unless there is good reason not to do so. Which means, does it say, Justice M.M. Kumar, that the NCLT will have to do application of mind? It shouldn't just merely because it has got an application from a financial creditor, it should admit it. So do you think the application of mind, which earlier wouldn't have been there, has been in a sense inserted via this judgment? I want to understand from you, sir.
Well, Tarun, in the earlier part of the judgment,
yes,
the bench has observed that the viability and overall financial health of the corporate debtor are not extraneous factors.
yes,
They are very relevant factors. In the context of the facts of that case, there was a decree, there was an award for a sum of rupee 1,730 crore.
Yes.
The claim made before the NCLT was much lower. So in those peculiar circumstances, it was said that the bench can apply mine, and if the financial health of a company is sound, for example, if there is an arbitrator award, maybe that in such a case, this law could be applied, that the award announced by the arbitrator is of much more value than the claim made in the application. In such like cases, maybe that but you see, I don't think this judgment would lead to opening up Pandora's box.
No.
Because otherwise, if subjective considerations start entering, if there is a infrastructure company, dues from the prospective buyers are awaited, and the dues are much more than the debt.
Yes.
What would be the situation? Can the bench refuse to admit the petition? How to go about it? Because a lot of subjectiveness is likely to come in if we apply this judgment in the manner it might be suggested.
So one follow-up question. Now we have left it to the wisdom of each member in the NCLT to apply his mind to the application before him.
Yes.
So do you think we have to wait to see how this judgment plays out in other cases before arriving at any conclusion? Do you think, because this judgment would be to the interpretation of each judge who is going to see matters before him? I want to understand that from you.
No, this, as I said, that if this judgment is interpreted, that each bench has to apply its mind and come to a conclusion with regard to the financial health of the corporate debtor, then it is endless thing. You see, in a peculiar circumstances where there is an award, maybe that one exception is created. But otherwise, as I said in my opening comment, 4 reasons have been given for paradigm shift in the policy. Para 64, 1, 2, 3, and 4. And those 4 reasons, to my mind, are extremely important. And reason 3 says, in a situation of financial stress, the cause of default is not relevant. You see, the cause of default is not relevant. That is what the reason number 3, Solicitor General of India gave these 4 reasons, which are accepted by the bench. So if the cause of default is not relevant, then how can an award, maybe of amount more than the claim, how can that would be relevant if the cause of default is not relevant?
You've raised an important point. I'll now go to Mr. Mahesh Agarwal. I would request you to consider point number 88, which I read out from the judgment. And I'm also reading point number 90, which is on the 34th page. The judgment authored by Justice Indira Banerjee, Justice J.K. Maheshwari says, we are clearly of the view that NCLT and also the NCLT fell in error in holding that once it was found that debt existed and a corporate debtor was in default in payment of the debt, there would be no option to NCLT but to admit the petition under Section 7 of IBC, which means the judgment clearly says NCLT has discretion. Could you delve on the discretion part for us, please?
No, so I will tell you something. I am in full agreement with everybody that this should not and does not open Pandora's box. The discretion which has been read into Section 7 has to be construed very narrowly.
Very narrowly.
And as we, like you said, new cases are dealt with, obviously parameters will be laid down
Yes.
The scope of exercise of discretion will be laid down as to what should be the parameter, what should be the scope of exercising discretion. So therefore, if a financial creditor comes with a case where there's a debt and there's a default, should the company straightaway be sent into IBC, or there are some exceptional circumstances, or there is a scope of exercise of discretion where the NCLT must evolve another method or defer or deny the relief?
One 10-second comment from you. Because apples and oranges are different, infrastructure companies and consumer durable companies are entirely different pieces. Do you think the court would also evolve to consider these things? Because you highlighted in your last answer why infrastructure companies, there is no asset creation which can be sold to recover the debt. One 10-second answer on that issue from you, please.
So therefore, once these parameters of discretion are laid down, I'm sure these issues will be, ironed out, and the objective will be that IBC should not be frustrated. It is nobody's suggestion that IBC should be frustrated. But at the same time, resolution must be fruitful. It should not be against public interest. Merely a technical default should not lead a company into IBC.
That's a fair
the basic objective.
That was the statement of the day. A technical default shouldn't lead a company to IBC. Now, last two comments I take from Mohit Saraf, Managing Partner, Saraf and Partners, and then Justice M.M. Kumar to close.
Actually, if you see the paragraph 90, it only uses the word, there would be no option to the adjudicating authority. So here what the court has given is only an option, additional option. It is not given a right for a borrower. It's just given that in case if something so blatantly, and it's a technical default, if there are certain issues, and again, you have to read this judgment along with the entire jurisprudence. You can't read this judgment against the entire jurisprudence in last 5 years. And therefore, it will, yes, I would say a difficult promoter, can it use this? Answer is yes. Can it delay? The answer is yes. But I would say the option is only on NCLT and NCLT. It's only an option. It's not a right. It's not a right created. And therefore, and they said that this option cannot be used arbitrarily. And therefore, just because if it is not admitted in 6 months, it will get revived. I think those are not good options. I would say it's an exceptional situation. Let's assume in a company there are 2,000 crore debt, and there is one financial creditor which owes 50 crore, wants to drag this company into NCLT. And that situation, and there is a debt not due. In that situation, and often this happens, that one bank is trying to put other banks in a default situation. So if that is the case, then in that situation, the courts can look at it differently. And I would say that yes, can it create a risk of delay? Yes. But I would say the jurisprudence will develop over time where it does not, it implies in an exceptional situation, the courts do not feel, I would say, constrained not to help. That's the only situation.
I've taken your point. Before taking the final comment from Justice M.M. Kumar, First President, National Company Law Tribunal, sir, I want to ask you, time and again, the Supreme Court speaks about constitutional morality, where constitution has to be read with the present societal context in mind. Though it was written more than about 70 years ago, you read it within the present societal context, which is the same words interpreted to mean differently. In the same way, has this judgment also meant that there will be a certain application of mind in NCLT via the judges to read each case in the particular context that it's being filed, whether it's an infrastructure company, NBFC, and then you would be able to better share this with us in your final comment.
Tarun, I don't think so that the judgment gives that wide discretion. Honorable judges have clarified in para 86 and 87.
Yes.
They say that although section 7.5 capriciously or arbitrarily,
yes,
certain circumstances warrant exercise of discretion in a particular manner, discretion would have to be exercised in that manner. The honorable judges, I feel, they have administered a caveat in para 87 again. They have said that ordinarily the adjudicating authority would have to exercise its discretion and application under Section 7 of the IBC and initiate CIRP on satisfaction of the existence of a financial debt and default on the part of the corporate debtor in payment of the debt, unless there are good reasons not to admit the petition. Although even this exception, which has been carved out by the bench, may not be consistent with the law laid down so far. Even this Mahindra judgment, which Mohit was referring, I think that is 3-judge bench. Somebody will have to think whether merely because the word may has been used. Now, in the context of this, then personal guarantor matter under Section 95, the word may has been used. Everything will go topsy-turvy then. If we start reinterpreting the IBC, then it will be difficult. You see, one of the reasons given is certainty. If there is no certainty and subjectivity comes in, then to resolve the crisis, stress, and the NPA would keep increasing. And you know the fast depleting assets of once the CIRP process start or the application is pending, the value of the assets start depleting very fast. Once you are in litigation, there are no buyer. The worth of the company, share of the company, they don't sell in the market the way they were earlier selling. So if the CIRP is there and ultimately it results in a time-bound manner to a resolution, somebody else come and take over the company, then it may be a much better way than keep on deferring the way this judgment has suggested, that keep on deferring 6 months or 1 year. How long?
Yeah.
It can defer.
I've taken your point up, and I would also like to, in a sense, agree that one episode may not be enough to deliberate on the impact of this important judgment. I think it would be prudent for us to revisit this issue in 3 weeks to 1 month and see how it impacts other cases in the NCLT and NCLT, because of course this will be, in a sense, taken into consideration by all the members of the NCLT. But today was a good discussion. I'm sure all the stakeholders who have found it useful. I would like to thank Mahesh Agarwal, Managing Partner, Agarwal Law Associates, Mohit Saraf, Managing Partner, Saraf and Partners, Justice M.M. Kumar, First President, National Company Law Tribunal, for making time and sharing us their opinion about this judgment, and looking forward to have you all three soon when we revisit this issue 3 weeks from now. Thank you so very much.
Thank you. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.